On December 5th, 9 justices at the Supreme Court of the United States will sit down in a closed-door conference and quietly decide whether millions of law-abiding Americans are potential felons for owning the magazines and rifles they already have. In one morning, 3 major Second Amendment petitions, Duncan v. Bonta, Gator's Custom Guns v. Washington, and Viramontes v. Cook County, are on the table, targeting statewide magazine bans and local AR-15 assault weapon bans all at once. If you live in places like California, Washington, or Illinois, or you simply own standard capacity mags and a modern rifle, what happens in that room could decide whether the Second Amendment is a real constitutional right or a regional privilege. Today, I'm going to walk you through exactly what these cases are, what the justices can do on December 5th, and how it could redraw the gun control map overnight. From second-class right to Supreme Court showdown. When we talk about where we are right now, you've got to remember how we got here. For years after Heller, McDonald, and even Bruen, the Second Amendment was still treated like a second-class right in a lot of courtrooms. On paper, those cases said you and I have an individual right to keep and bear arms, that it applies against the states, and that judges are supposed to look at the text of the amendment and our history and tradition, not run some balancing test about whether they personally like guns. In reality, plenty of lower courts and legislatures just kept doing what they were already doing. They just changed the labels on the test. Instead of saying, "We're weighing your rights against public safety," they rewrote it as, "We don't think this particular arm is really covered anyway." That's how we ended up with this mess. A Glock with a 15-round magazine is normal in one state and contraband in another. An AR-15 is the most common rifle in America in one zip code and a banned assault weapon in the next. This conference is the point where the Supreme Court can either let that patchwork harden into concrete or step in and tell these lower courts, "No, the rules we gave you mean something." These 3 cases matter because they don't nibble around the edges. They go straight at the magazine and rifle bans anti-gun states use as their favorite workaround. Duncan v. Bonta, California's magazine ban on trial. Let's start with Duncan v. Bonta, because this is the one a lot of you already know. In California, Penal Code Section 32310 basically says if your magazine holds more than 10 rounds, the state wants it gone. It doesn't matter that millions of those magazines were bought legally, over the counter, for perfectly normal pistols and rifles. The state relabeled what the rest of the country calls standard capacity as large capacity, and then tried to make simple possession a crime. A federal district judge, Judge Roger Benitez, looked at that law and said, "No, this is unconstitutional." He pointed out that these magazines are in common use for lawful purposes all over the country, and that California couldn't point to any real historical tradition of banning a core component of ordinary arms. For a moment, gun owners in that state actually had their rights recognized. But then the Ninth Circuit Court of Appeals stepped in. A 3-judge panel agreed with Benitez, but the full en banc court reversed and upheld the ban, even after Bruen told courts to stop playing games with interest balancing tests. So now, Virginia Duncan and the other plaintiffs have taken this fight all the way to the Supreme Court of the United States. Their petition asks 2 very simple, very important questions. First, are these so-called large-capacity magazines actually protected by the Second Amendment as arms or essential parts of arms? Second, when the state bans and effectively confiscates millions of lawfully acquired magazines without paying their owners a dime, is that also a violation of the Constitution's protection against taking private property without just compensation? Here's why that matters to you, even if you don't live anywhere near California. If the Supreme Court takes Duncan and clearly says, yes, these magazines are protected, and no, you can't just outlaw them, that ruling doesn't stop at the California border. It sends a shockwave through every other state and city that's built its gun control agenda on the same 10-round limit. Overnight, the legal footing for those copy-and-paste mag bans starts to crumble, and the lower courts that have been dodging Bruen's rules will have to answer for it. And if the court also takes the takings clause issue seriously, it sends another message. States don't get to trample your rights and your wallet at the same time and then walk away like nothing happened. Gator's custom guns versus Washington, when a state court redefines arms. Now, if Duncan is about a federal appeals court refusing to treat magazines as part of the right, Gator's custom guns versus Washington takes it one step further. Here, we're not talking about a federal circuit. We're talking about the Washington Supreme Court itself saying, in plain language, that magazines holding more than 10 rounds are not arms at all. In other words, in their view, they sit completely outside the protection of the Second Amendment and the state constitution. This all comes from a law called ESSB 5078, which bans the manufacture, import, sale, and distribution of magazines over 10 rounds in Washington. A trial court originally said, no, this violates the right to bear arms, and blocked it. But when the case got to the Washington Supreme Court, the justices reversed that win. They said you still have access to smaller magazines, so the state hasn't really interfered with your core right to self-defense. They treated the larger magazines like a luxury accessory. The state can take away any time it feels like it. The danger in that logic is pretty obvious. Once a court decides that a core component of how a modern firearm actually works is not really arms, there's no clear stopping point. Today, it's so-called large-capacity magazines. Tomorrow, it could be certain triggers, certain bolts, or any other part that politicians decide is non-essential. When you zoom out, it's a clever way of hollowing out the right without ever admitting that's what they're doing. That's why the petition in Gator's Custom Guns asks the Supreme Court to step in and answer a very basic but very loaded question. When a modern pistol or rifle is designed and sold with a magazine over 10 rounds as its normal configuration, can a state simply declare that magazine not an arm and ban it? If the justices say no, that's not how the text and history of the Second Amendment work, then Washington's theory collapses. And so does a big piece of the blueprint other states are using to attack your rights piece by piece. Viramontes versus Cook County. Are AR-15s protected or prohibited? The third case in this lineup shifts the focus from magazines to the rifles themselves. Viramontes versus Cook County comes out of Illinois, where Cook County has had an assault weapon ordinance on the books since 2006. That ordinance bans a long list of semi-automatic rifles, including the AR-15 platform that millions of Americans own for everything from home defense to competition to just plain range time. After Bruen, a group of plaintiffs backed by groups like Firearms Policy Coalition and the Second Amendment Foundation challenged that county-level ban in federal court. They argued something pretty straightforward. If the Supreme Court has already said the Second Amendment protects arms that are in common use for lawful purposes, and AR-15 rifles are now one of the most common rifles in the country, how can a local government just outlaw them for ordinary, law-abiding people? The district court didn't buy it, and neither did the Seventh Circuit Court of Appeals, which upheld the ban and treated it as compatible with Bruen. That's how we end up with the petition now sitting at the Supreme Court. The question in Viramontes is not buried in legal jargon. It asks, in essence, do the Second and 14th Amendments protect the right of regular Americans to own AR-15-style rifles and similar semi-automatic rifles? Or can places like Cook County treat those rifles as contraband, even while millions of them sit legally in safes across the rest of the country? If the justices decide to take Viramontes, they will finally have to answer the question that a lot of lower courts have been trying to dodge. Are AR-15s the kind of dangerous and unusual weapons that can be banned? Or are they exactly the kind of common, multi-purpose arms the Second Amendment was written to protect? For people watching from New Jersey, New York, Illinois, and other states with aggressive rifle bans, a strong ruling here could flip the script. Instead of you being forced to move, disarm, or register, hostile jurisdictions would be the ones scrambling to explain why their bans survive when the court has already said the right belongs to the people, not to the government's list of approved hardware. And just like with the magazine cases, whatever the court says about AR-15s in this context won't stay trapped inside Cook County. It will echo through every courtroom still pretending those rifles sit outside the heart of the right to keep and bear arms. What a Supreme Court conference really is. Now, before we talk outcomes, let's clear up what this December 5th conference actually is, because it's easy to misunderstand. This is not an argument day. There are no lawyers at the lectern, no cameras, no dramatic speeches. A conference is when the 9 justices of the Supreme Court meet behind closed doors, go through the stack of petitions, and vote on what to do with each one. For every case, they can decide to grant a full review, deny it, send it back to a lower court with instructions, or relist it for another conference and think about it longer. Orders from a conference usually come out the following Monday, and sometimes sooner. So when these 3 petitions hit the December 5th list, that's the moment where this all turns from theory into reality. Either the court is going to engage with mag bans and AR-15 bans, or it's going to look the other way again. Best and worst case scenarios for your rights. So what are the possible futures here? In the best case scenario, the Supreme Court grants at least one of these cases and uses it to say something clear and simple. Magazines that come standard with modern pistols and rifles are protected, and AR-15 style rifles that millions of people own for lawful purposes cannot be banned just because certain politicians don't like them. That kind of ruling would pull a lot of lower courts back in line with what Bruen already said about sticking to the text of the Second Amendment and our history. There's also a middle ground possibility where the court sends a case back to a lower court with instructions to apply Bruen correctly, which still puts real pressure on the anti-gun jurisdictions. The true worst-case scenario is denial across the board, leaving this fractured map in place and telling hostile states they can keep treating your rights like a local privilege instead of a national guarantee. At the end of the day, this all comes down to one simple question. Is the Second Amendment going to be treated like a real constitutional right or a privilege that disappears at a state line? On December 5th, the justices of the Supreme Court are going to make some choices that point us one way or the other on magazines and AR-15. I'll be watching every order and every update from these cases, and when something breaks, I'll be here to walk you through it in plain English. If you want to stay ahead of it, make sure you're subscribed, hit that notification bell, and share this video with somebody who owns standard capacity mags or a modern rifle. They deserve to know what's on the line.